Hello and welcome back to our Title IX training series. My name is Dean Shatley from the law firm of Campbell Shatley, and I'm joined with my colleague Ashley Leonard today. We are covering Section 3 key Title IX personnel in this presentation. So this presentation is designed primarily for the Title IX coordinator, as well as any other school administrator involved in the process who wants to learn more about their role or the roles of others in the Title IX process. So let's just jump right in and let's talk about who these people are and who they're going to be, who they're not going to be. Sometimes that's the question, whether to be or not to be, I guess. But let's first start with the Title IX coordinator, and we are going to talk in depth about who the Title IX coordinator should be, the types of administrative qualities they should also have. But the Title IX coordinator overall oversees the process. They guide the process from start to finish through the investigation, through the determination and appeal. But they started even initially from meeting with the complainant, producing the documents about the complaint for both the complainant and the respondent, and then kind of pushing into the investigation. The Title IX coordinator, however, does not investigate the matter. They do not make any determinations in the matter. In fact, they typically will stay neutral throughout the entire process. Investigators is the next key personnel. Obviously, this is the person who is going to investigate any formal complaint that is not resolved through informal resolution. An investigator under the North Carolina School Board Association model policy is typically, for students, it is typically the principal or designee, and for employees, it is the human resources director or someone else in HR or designee as well. Advisors. Advisors are a little elusive in the K-12 world. In the higher education, again, in college and in university, the universities are required to appoint advisors during the hearing stage. This is not the case in K-12, but we will talk more about advisors. The good thing is that school districts are under no legal duty or obligation to appoint advisors, but the parties may appoint or bring their own advisors. Next, we've got the decision maker. In the School Board Association model policy, this is generally the superintendent or his or her designee. This, just as it sounds, this is the person that makes a decision after receiving the investigative report. Then we have the appeal decision makers. This is in the School Board Association model policy, the board or a panel of board members and will review the superintendent decision maker's decision and potentially make any changes or remand it back down for further investigation or for further consideration by the decision maker. Lastly, we have the informal resolution facilitator. Again, this is not necessarily somebody, it has to be one person in the district. It could be multiple people, but it is someone who is very important to the process, someone who can hopefully make the process more efficient, resolve complaints, but especially complaints between students, potentially complaints between employees as well. And so we'll talk in depth a little bit more about them as we move forward. So let's talk about the Title IX coordinator. The Title IX coordinator, as I mentioned earlier, is to oversee the district's response to Title IX reports and complaints, and then address any patterns of systemic problems revealed by such reports and complaints. So the Title IX coordinator does have the ability to address larger issues in the school district, to make recommendations about those larger issues, such as this school might need sexual harassment training, or make recommendations in regards to employee matters if there's some sort of pervasive conduct going on with a group of employees. But overall, their overall duty is to guide and oversee our response, the school district's response to Title IX formal complaints. They have to have knowledge of Title IX. They have to have knowledge of the rules and the requirements. So make sure these folks really understand the rules or have the ability to learn the rules throughout this process. So here is probably the primary duties for the Title IX coordinator in preventing, investigating, and remedying sexual harassment in the district. So first and foremost, you have to ensure that your policy and grievance procedures are updated, that they meet the new standards of the new Title IX regulations. If you have adopted the North Carolina School Board Association model policy on sexual harassment, then you are, as of now, you are in compliance with this. If you do not use the North Carolina School Board Association model policy and you have not updated your policy manual on Title IX, it's time to do so as quickly as possible. Please discuss this with your local counsel if you haven't done that already, and make arrangements to update your policy and procedures in regards to sexual harassment. Title IX coordinator is also responsible to give notices to staff and students about Title IX, how to file complaints, how to report complaints. It is also their job to ensure formal complaints. And we'll talk a little bit more about the difference between complaints and formal complaints once we get to Section 5, I believe it is, and we're talking about responding complaints. But we have to make sure that these formal complaints are investigated and are investigated promptly, thoroughly, and equitably. And to ensure appropriate steps are immediately taken to prevent imminent harm to either party, the complainant or the respondent, and also potentially even witnesses too who are participating in the investigation. And so these are usually called supportive measures, and we'll talk more about supportive measures in responding to complaints, but it is up to the Title IX coordinator to implement supportive measures or to recommend supportive measures to those administrators who have the power to implement them. Then probably one of the largest responsibilities the Title IX coordinator has is to make sure everyone is appointed, that they know their role, and that they are trained. Of course, this is really the entire purpose of this Title IX training series, is so the Title IX trainer doesn't necessarily have to do all the training himself or herself. That you can say, investigators, watch this video, decision makers, watch this video or videos. But it is your job to, one, make sure that they know who they are and that they are trained either through this series of videos or other professional development. That includes your board members who are going to be your appeal decision makers too. Make sure they are trained as well. Two last things that are kind of within the bailiwick of the Title IX coordinator, and that's making sure that you keep a good file. And you need to have several different files. One, you're going to have like a training file on an annual basis, what kind of training you did, who participated in the training, what their role is, when you did it. And then you're going to have files on complaints that come into the Title IX office, and how they were handled, how they were processed, if they were immediately dismissed because it didn't rise to the complaint didn't rise to the level of sexual harassment or didn't occur in an educational program or activity, or whether it moved on to the formal complaint stage and what happened in that. So keeping good records is going to be imperative. I can't tell you how many times I've been in litigation, sexual harassment litigation, and the other side, the former employee or the former student's attorneys, ask for training materials on sexual harassment, and the district just throws up its hand and says, well, we know we've done it, but we can't find it. And so it's really going to be up to the Title IX coordinator to keep up with this. And then lastly, to also ensure proper interaction with law enforcement as well. Let's talk a little bit about who the Title IX coordinator should be and who they shouldn't be. Let's talk first about some qualities. They have to be able to push and guide this process. They really need to make sure that they can keep it on track. There are certain timelines. We'll talk about those timelines later, but they really got to do that. They also have to be very organized. They've got to keep, again, all these records in place. They have got to be able to handle multiple complaints at the same time, especially in larger districts. In some smaller districts, you may only get one or two a year, but they need to be able to process these complaints as well. They need to know the rules, so you need to know the rules, or you need to be able to learn these rules as quickly as possible because they are complicated, and the overlay with state due process rights for students and employees is sometimes difficult as well, which we'll talk more about in the hearing section. They have to be empathetic. So a Title IX coordinator has to be able to talk to parents and students and employees, not only to explain the process, but also to be able to understand, so the parent or the employee and the student understands that their concerns have been heard, and that they believe that they're going to get a fair shake in this process. Even if the outcome doesn't go in their favor, that the process will be equitable and it will be objective too. And sometimes the Title IX coordinator needs to be able to get in there and act immediately. And don't take this the wrong way, but before a principal screws something up. We've talked a lot about, or will talk a lot about, it's up to the principal and assistant principals and teachers to report allegations of sexual harassment to the Title IX coordinator, so the Title IX coordinator can process that, determine whether or not it needs to move into the formal process with a formal complaint. But a lot of times a principal may think, well, this doesn't have anything to do with sexual harassment, and may ultimately discipline a student before sending the complaint on, and they really should be able to get in there and make sure they act before a principal gets too far ahead. Now, Ashley, I talked a little bit about the qualities of Title IX coordinator. Talk maybe a little bit about what type of other role should, what type of other position, I guess is what I'm trying to say, should fill the Title IX coordinator position. In a lot of smaller districts, they won't have the ability to just appoint one person and all they do is serve as a Title IX coordinator. So who else could serve or shouldn't serve in this role?
I think those positions that could serve as a Title IX coordinator are those, if you have them, existing positions of other civil rights kind of watchdogs. So your EC director, if you have an affirmative action officer in HR, that could potentially be your Title IX coordinator, kind of doubling up on different federal law requirements with one position, even though you're looking at different types of civil rights. They kind of go hand in hand. Who it should not be. So like Dean was saying, your Title IX coordinator should not be your investigator or your decision maker or your appellate decision maker. So if you're following the School Board Association model policy, your investigator is going to be principal or your senior HR official. Your decision maker is going to be the superintendent, and then your appellate decision makers are board members. So I would count all of those positions out as the Title IX coordinator. Possibly an assistant superintendent of some sort, but you want to be careful if that assistant superintendent reports to the superintendent. You just want to be careful of any perception of conflict or bias. So there are some limitations on the best position for the job, but I think there are some existing positions that you can utilize and kind of tack on some additional responsibilities like your EC director.
And great points. And I think it's more about who it shouldn't be sometimes than who it should be, because in every district will be a little different. But one other point I want to drive home is the Title IX coordinator's duties is much more than just helping oversee the complaint process. The training process, being able to identify systemic harassment or systemic problems, pervasive problems in a school building or in an office, and being able to do something about it is highly important too. Investigators. Who can be an investigator? Again, under the School Board Association policy, it is generally the principal in student matters or someone in HR, your HR director, maybe for employee matters, where the employee is the respondent. But technically, it can be anyone. And some districts may have, especially larger districts, may have investigators or employee relations departments who have people that serve in an investigative role, and that's completely okay. I really think that the School Board Association put it in as principals because they typically do investigate student misconduct. Even if it's bad misconduct, they may get some support and assistance from the central office. But generally, the principal or the principal's designee, such as an assistant principal or lead teacher, will investigate student conduct. However, again, it's not so much who an investigator can be, it's who an investigator shouldn't be. And an investigator should not be anyone that is otherwise involved in the process or has another role in the process, such as the Title IX coordinator, decision maker, or decision makers designee. Certainly shouldn't be a board member anyway. Board members should not be investigating things at all, whether they're sexual harassment or not. The investigator has to be trained in how to conduct the investigation. We have a video, hour and a half long, specifically on this issue for your investigators to watch. Now, if all of your principals are investigators, or you're going to designate your principals as investigators for student issues, that means all your principals are going to have to watch this video or that video on an annual basis, or some other kind of training on an annual basis to get updated. Now, we also want to make sure that if you have a principal who come 2022 and has not, they've done an annual training, but they've not actually conducted an investigation and they've forgotten their annual training. That's why we've made these videos, so the investigator can just pop the video up on their computer screen or on their iPhone and watch it before they move into the investigation stage. But it's very important that they investigate in an objective, unbiased way. And we are going to talk a lot about bias and conflict of interest here at the end of the presentation. They also are going to have to be able to create an investigative report, which will include issues of relevance, how to determine whether or not evidence is relevant or not, and that'll be included in the training for investigators as well. Decision makers, again, this is generally the superintendent or designee, and what the School Board Association was trying to do, I believe, is align their policy with the person who already makes decisions on employee issues and substantive or substantial school discipline issues, such as long-term suspension. But it doesn't have to be the superintendent, but it should be somebody who has authority to make those kinds of decisions or can at least recommend it to the superintendent. It makes most sense, especially in smaller districts, that the superintendent is the decision maker, especially in employee matters. Certainly an assistant superintendent could be, or somebody like that, in student matters, but it's still the superintendent is the only one who can long-term suspend a student. And so we would recommend, especially in smaller districts, that the superintendent do that unless those duties have been delegated to some other key personnel within the district. And certainly larger districts sometimes do that. Again, the decision maker, though, can be anyone that doesn't have, a conflict of interest or a bias or some sort of preconceived notion of the issues of the parties. And so if the superintendent's son is accused of sexual harassment at a school and we go through this process, certainly the superintendent would not be able to serve as the decision maker in that process and would have to appoint somebody else as well. But I think it's a pretty common sense notion at this point in time, even in other investigations. And again, the superintendent is going to have to be trained in issues of relevance and the evidence, how to determine whether evidence is relevant or not, and that is included in the decision maker and decision maker determination portions of our training. Appellate decision makers, model policy provides that the board or a panel, we would almost always suggest that you use a panel unless it is something that results in like the termination of a career status teacher or a teacher during a contract where you might be more inclined to use the full board for a hearing. But if it involves sexual harassment and you do use the full board, that means the entire full board will have to go through training. So that means somebody's going to have to tell them to either sit through a training that's specific to making appellate decisions in the Title IX process, or you're going to have to show them the video or train them yourself as the Title IX coordinator. But just going to the School Board Association conference and just watching an hour-long presentation on the new policy updates is not sufficient training for this compliance requirement. They need to watch a training specifically on appellate decision-making within the Title IX process, because they really need to be well-versed in the policy, including the basis for appeal and what are the available options. And all that's discussed in our training series, but there are different options, including not making a decision and sending it back for further investigation or further consideration of an issue that the decision maker left out too. Additional Title IX personnel. The advisors and informal resolution facilitators, or another word might be mediators if you want to use these. An advisor can be anyone. Now, like I mentioned in the beginning of the presentation, the district has no obligation to appoint an advisor. So you don't have to worry about that. You can, but you don't have to worry about that. We'll talk about that in a second. However, the parties, the complainant and the respondent, can bring an advisor with them, and it could be an attorney, it could be their uncle, it could be their neighbor, it could be their preacher, doesn't matter. They can bring an advisor at any stage of the process, a meeting with the Title IX coordinator, a meeting with the investigator, a meeting with the decision maker, a hearing, etc. So keep that in mind, that they can bring somebody. And the Title IX coordinator, when you're writing notices about these meetings, or the investigator gives notice of meeting with the investigator for an interview, you should give notice that they can bring an advisor if that's what they want to do. Now, they can only participate during a hearing if your district provides Title IX live hearings. And we'll talk more about live hearings later, and we talked some about that in Section 2. But we don't have to provide the advisors. Otherwise, they can be present, but they really shouldn't interrupt the proceedings, even in like an interview. They shouldn't interrupt or try to stall the investigator. They can be there. They can be supportive. They can certainly step outside and talk to their advisee or client if it's an attorney, but they should not be disruptive to the process. Ashley, what do you think about a school district actually appointing advisors, even if they don't have to? And if they chose to appoint some advisors, what cases would they appoint advisors in, and who would serve in this role?
I think it's going to be really up to your district if you want to provide advisors. One thing to keep in mind is there's a principle underlying these Title IX regulations, and that is that the process should be equitable. So everything that you do for one party, you should do for the other. So if one party has an advisor, particularly if that advisor is an attorney, I would definitely want to consider whether to provide an advisor for another party who does not have one, just to try to maintain equity amongst the parties, although you definitely do not have to. If you choose to provide an advisor, or if you're considering appointing an advisor during the process, you want it to be someone who's trained with at least Title IX fundamentals and what the process looks like. So keep in mind that that would be additional training that you need to provide a district employee. Or it wouldn't even have to be a district employee. You could appoint someone as an independent contractor. Again, using the example of one party has an attorney, the other party doesn't have anyone, and you want to maintain equity, you might consider appointing an attorney who would do this pro bono to maintain equity. And so you want someone who's trained in the process, who understands what Title IX is, and also who understands what their role is an advisor. Again, it's someone to provide support and guidance to the party, him or herself, but not to participate in the process unless you're providing a hearing. And just a note, if you are using the School Board Association's model policy, the model policy does provide students an opportunity to request a hearing. In those cases, advisors may participate, ask questions of witnesses, and ask questions of the other party. So keep that in mind as well.
Thanks, Ashley. And those are all great points. And one other point I want just to underline is, again, there's no obligation to do this in K-12 education. There may be some cases, and you bring up a good one, where, if a respondent has an attorney, do we want to encourage or appoint some sort of advisor, whether it's an attorney or not, to the complainant? I do think there is also, if you have in most cases, I don't believe folks are going to have attorneys as advisors unless there's something big at stake. It's maybe the respondent has also been charged criminally, and so they have a criminal attorney. But there may be instances where there is a lot at stake and neither party has an advisor. And the school district thinks that just for really, I think for the emotional and social well-being of both kids, that an advisor might be appropriate. Not maybe not an attorney, but maybe a counselor or somebody like that who can just be there with them. Especially if the kid doesn't have a supportive parent. So none of this stuff is easy. And I mean, and when we really talk about some of the hard cases, we're talking about sexual assault potentially, dating violence, those sorts of things. So it can't be easy for a complainant to come forward and go through this. And it potentially is probably not easy and very stressful on a respondent, even if the respondent is as responsible for the conduct as the complainant alleges. And to have somebody there with those folks who can just kind of be there for them as a support mechanism might be appropriate. So, we kind of wipe our brow and say, whew, we don't have to do this. The colleges do. But it is potentially a good consideration, I think, for K-12 to consider or to think about in specific cases. So let's also talk about the facilitators. Again, the facilitator can be anyone in the district. It can be anyone, absolutely anyone, except for other Title IX personnel. It doesn't have to be a district employee. You could use, for instance, somebody outside the district. Like a lot of communities have mediation centers. You could use somebody from the mediation center, but they should have a strong understanding of how Title IX works and the process, and that could be going through a couple of these trainings, other professional development, reading the policy. But I will tell you that do not overlook having a good facilitator. A good facilitator should help the district resolve a lot of complaints. Some complaints will never be able to be resolved, and I totally understand and get that. And we'll talk more about the informal resolution moving forward, but make sure you find good facilitators, people who can listen, people who can empathize, and people who can get the job done, because this is where we are going to make the process work for the parties and the district. This is where we want to make it efficient. And so use a facilitator to help resolve a lot of these cases. So lastly, as we move through just to the very end of this, let's talk a little bit about bias, conflict of interest, and recusals. Title IX is very clear that any key personnel participating in the process of a complaint cannot be biased to one party or against one party. And they can't have a conflict of interest, meaning they can't have a financial interest. They can't have a familial or family interest with any of the person. And I would also kind of extend that to say maybe even a very friendly relationship, such as, well, the respondent is the son of my neighbor and we're good friends. We cook out together all the time. We've been on vacation together. And so, the principal should not serve as the investigator in that kind of role, and should send it to a designee and talk it out with the Title IX coordinator. Again, though, it is up to the Title IX coordinator to kind of sniff out these biases and conflict of interest and ensure that they don't happen. A conflict of interest is a grounds for appeal of the final decision. And so we always want to make sure that we get ahead of this and we identify bias and conflict. So when we're training our investigators, when we're training decision makers, we have to train them that it's up to you to point out any potential apparent or real bias or conflict of interest at the very beginning of this. And let's talk about whether or not you have to recuse yourself. Now, there are a lot of forms of bias and prejudice. Basically, one way to look at it is you can't go in there and objectively look at this. You can't go in there and not think, well, that person is not telling the truth, or this person must be telling the truth. And so you really need to go in there being neutral and objective, kind of a nonpartisan approach. If you are leaning towards one side or the other and you've not even started the process of investigating or making a decision, then you have a bias. Certainly there is implicit bias or confirmation bias as well. When a senior level official or administrator wants to intervene in the process, we kind of understand that there might be some sort of bias or prejudice there too. But it can also simply mean just animus of any kind. So again, it's up to the Title IX coordinator to kind of sniff this out, make sure that it doesn't happen, and that these folks, if there is any kind of bias or conflict of interest, that they recuse themselves as well. So training for all employees. Ashley, I don't think the School Boards Association policy has a policy requirement requiring all employees be trained on an annual basis.
Right, it doesn't.
Okay, so you don't have to do it, but what are the things that all employees should know about Title IX? Ashley?
Oh,
Sorry. My handoff was bad. I apologize.
so even though the School Board Association model policy doesn't have an annual training requirement for all district employees, you should consider whether you want to provide annual training in some form or fashion, whether you're including it as part of other training that you already provide annually to all employees, because it is important that all employees know who the Title IX coordinator is and how to direct students and employees to that person if they want to make a Title IX report or complaint. So all employees, all district employees under the Title IX regulations, if it basically impute liability to the school district if they have knowledge of alleged sexual harassment. So if a student or employee comes up to a custodian or a bus driver or a coach or a teacher or an administrator and say, I was sexually assaulted last night, or I'm being sexually harassed, anything involving sexual harassment, that employee then has imputed knowledge to the district that there could be a report of sexual harassment. So then it's up to the district to respond to that report. So if that employee doesn't know who the Title IX coordinator is or how to direct students or employees to make that report, that really increases district's liability under Title IX. And we've explained that actual knowledge piece of sexual harassment in other videos. But I say all that just to emphasize the importance of who the Title IX coordinator is and how to report for all employees on an annual basis.
And the key thing is that we want to train employees, because if that employee has knowledge and doesn't do anything about it, that imputes liability onto the district. I mean, you hit that dead on. And let's talk about this. You don't have to hold some massive district-wide video conference or training at the beginning of the year. You certainly can, and I wouldn't say don't do that. And the Title IX coordinator doesn't have to go to every school in the district and do a training. Certainly you can. The size of your district may determine what you can and cannot do logistically. But this kind of training could come in a lot of different forms. It could be a memorandum or an email sent to all employees and staff. Hey, have you ever witnessed or heard about sexual harassment or sexual misconduct in your school building? Here's what to do about it. You can put signs in the break room, in the workroom, on student bulletin boards. You know, I mean, wouldn't it be great if an employee who is a predator, we don't know he or she's a predator, but is a predator, and they see every time they walk in to get a Coke or a Diet Coke out of the drink machine or make copies, they see this sign that says, report sexual harassment, sexual misconduct, sexual assault to the Title IX coordinator. You know, it has all this information right there on the bulletin board. Maybe that stops this person from doing something with a student at some point in time too. So you know, we really got to get the word out. And every few years, I just see where we go through this lull, and it's like we have to drive in this reporting requirement again. And I think we're in a lull right now. Last year, I had several clients who had employees just fail to report heinous sexual harassment and misconduct occurring between students, between an employee and a student. It doesn't matter, but just fail to do it. And and it's just kind of a horrible situation. So make sure all our folks have the knowledge, these three things up there that are on the slide. So Title IX training for your key personnel folks. Now you got to do it annual. We've talked about this. You got to do it for the coordinators, the investigators, the decision makers, the facilitators. If you have folks working as advisors, we certainly would say do it for those too. What do you train them on? We got to train them on the definition of sexual harassment for Title IX. It's a little different. We've talked about that. The scope of education programs and activities. So what is an education program and activity? What is not? And how to conduct an investigation and grievance process for those investigators, including hearings and appeals and informal resolution, for the appropriate personnel. So they got to know how to do their part, and they have to know how to do it well. They need to know how to serve impartially without bias and conflict of interest. If you're going to use technology at a hearing, if you do have a live hearing, or you just will allow hearings to occur when they're required under state due process laws, like a long-term suspension or employee dismissal hearing, and you're going to use technology, train them on that. That's complicated. I can go to a trial and I've got to, work on the technology that the courtroom has for an hour or two before I kind of really understand it. We all have to get trained on it. And so, especially during a pandemic, if we have any hearings occur, to be able to use that technology and be able to use it efficiently. You have to train, especially the investigators and the decision makers, on issues of relevance and evidence at the hearing and during the investigation, and we've included that in our trainings, and also issues of relevance in creating the investigation report and how you do that. And so these are all covered in our training series, but these folks need to understand their parts of this and be trained on an annual basis. Lastly, all training materials must be posted on the district website. Certainly you can post this PowerPoint in a PDF or just a full PowerPoint version, and we've included it. You can post it on the website. We do not recommend or authorize the posting of the videos, however, for a lot of reasons, which we're happy to discuss outside of the videos. But please post this. Please post any other materials from other trainings that you've done on an annual basis or even on a one-time basis for your folks, and any training materials that you as the Title IX coordinator create. That content too. For instance, if you create training materials for all employees, whether it's just a short video or a short PowerPoint or a short memorandum, put it on the district's website too. And we're talking about the public website as well. So that is it, folks. That finishes up for this section. Thank you, Ashley, for participating, and we will see you at the next section, and thank you very much.